We want to get started because we know we're all super busy, and I want to first thank all of you for attending today, and a huge thanks to Stacy Franklin, who really puts all this together, gathers everything, and so we couldn't do it without her. She's amazing, and thank you, Stacy, for putting this together. So as you know, this is our second virtual meeting. In some ways, I think it's easier for us because we're not traveling to Hartford or any other location. We're holding it. So I guess that's the positive of COVID, although we miss seeing each other live. So our first meeting, as you may recall, was in June during really the height of sort of the first wave. And here we are in December in the height of the second wave. So a lot of our focus the focus of this meeting will, of course, deal with the obvious, the COVID situation and how it impacts access to justice. I'm not sure if there are any visitors or members attending that we should welcome. I don't see any, Stacy, but what we thought we would do is go around the room, the virtual room, and have everyone introduce themselves. And so I see on my upper left, I think is Dean Ahmad. So if you want to go first, we can work that way. But I'm not sure I see everyone, but I could at least do the ones I see on the screen.
Great. Good morning, everyone. I'm Munir Ahmed. I'm the Deputy Dean for Experiential Education at Yale Law School, and I'm here on behalf of our Dean, Heather Gerken, and pleased to be with all of you.
Thank you. Krista?
Sorry. Good morning, everyone. I'm Krista Hess. I'm with Court Operations in Wethersfield. Nice to see everyone.
I'm sitting next to Krista. You all know who I am. And next to me is Dean Brown.
Good morning, everyone. I'm Jennifer Brown. I'm the Dean at Quinnipiac Law School. I believe at the June meeting, my colleague Brad Saxton was representing Quinnipiac because he was serving as interim dean while I did a year as interim provost at the university, but I'm extremely happy to be back at the law school and happy to be re-engaged with this group. So looking forward to working with you.
Great. Attorney Ogilvie.
Good morning, everyone. I'm Moy Ogilvie. I'm at the Hartford office of McCarter and English.
Attorney Saxton.
Good morning, everyone. My name's Jay Sexton. I'm an appellate attorney in Hartford, the outgoing immediate past chair of the appellate section for the CBA, and I'm also a co-chair of the Technology and Cybersecurity Committee for CBA.
I have Judge Bright.
Bill Bright from the Connecticut Appellate Court.
You should also know, I think she muted herself, but Allison Chandler is with us, and she's from External Affairs, and she's making sure that we are, this meeting, which is public, is being recorded on YouTube. I don't know if you want to pop in, Chandler, entirely up to you. Thank you, Chandler. Stacy, you're next on my screen.
Good morning, everyone. My name is Stacy Franklin. I am co-support staff for the Access to Justice Commission, and I work for the judicial branch.
I have Attorney Erickson, Ty Erickson.
Hi, good morning, everyone. I work for the Office of the Chief Court Administrator in the Superior Court Operations Division.
So now I've sort of lost some of you in my screen, so I'm going to go down the list, and please, if I miss you, let me know. Attorney Sciarretto?
Yes, good morning, everyone. Happy to be here. I am the Executive Director of Statewide Legal Services, a proud part of the Legal Services Network in Connecticut.
Thank you. Attorney Ferranti?
Good morning, everyone. I'm Jennifer Ferrante. I coordinate the Legal Incubator Program for the Center for Family Justice in Bridgeport and also serve as a staff attorney there.
Thank you. Dean DiMiola?
Hi, everyone. I'm Karen DiMiola. I'm the Assistant Dean for Finance and Administration at UConn Law.
Then I have Attorney Nelson, Chris Nelson.
Good morning, everyone. Chris Nelson. I'm an attorney at Nelson Votto, small firm here in New Haven. I am co-chair with Judge Diana of the Moderate and Modest Means Work Group. Judge Diana could not be here today and apologizes to everyone for that.
Thank you, Attorney Nelson. I also have, Attorney Dowd, Jeffrey Dowd.
Hi, I'm the supervising law librarian for Connecticut Judicial Branch.
I have Dawn Lavallee.
Good morning. I'm Dawn Lavallee, Director, Division of Library Development for the Connecticut State Library and co-chair for the Working Group on Public Libraries.
Thank you. Attorney Ogilvie.
You covered her already, I think.
Oh, I did. I'm sorry. Lucio DeLuca has joined us from IT. I don't know if you can see him, but Lucio, if you can hear us, if you want to introduce yourself. He may not be able to speak. He is joining us and he may be presenting along with Krista Hess on what their group is doing on video access and video conferencing in court proceedings. We also have, it looks like we have Dean Fisher with us, although he indicated he would not be able to attend, but he's in the same chat box. So I don't know if you can hear us, Dean Fisher. And I also show Sharon Wilson, who is works with the Chief Court Administrator's Office as an executive administrator. She may be in on this call as well. And I believe I identified everyone on the call. Let me ask, is there anyone joining us just as a member of the public attending the meeting?
Justice Khan, it's Judge Bizzuto.
Oh, of course.
No. And so I'm on from the Deputy Chief Court Administrator's Office. Good to see everyone. Thank
you, Judge Bizzuto. You know, that's really smart on my part to miss the Deputy Chief Court Administrator, right? I apologize. They're like right under my name as I went down the list. So I'm sorry, Judge Bizzuto. Yeah, really smart. So anyone else attending that has not been identified? Okay, so welcome everyone. The first order of business is approval of the minutes of our June 4th meeting this year. I trust everyone received first the link from Stacy and then earlier this morning the actual minutes. Let me first ask whether there's a motion to approve the minutes.
So moved.
Attorney Nelson, second.
Second.
Attorney Dean DiMiola, thank you. Any discussion? Let me first ask any all who approved the minutes. I'm not quite sure how to do this virtually, but let's do this. Let me ask, does anyone oppose the minutes? You can raise your hand virtually. Does anyone want to abstain from approving the minutes?
I should abstain since I was not in attendance in June. I will abstain.
Thank you, Dean Brown. So, and Can I assume everyone else would be in approval of the minutes? And if not, please speak up now. Okay, great. Thank you so much. So you have a copy of the agenda. Our next item is to get a brief report from all of the work groups and also just an update on what folks are doing. A lot of the focus of the reports will be on COVID-related issues. I understand some of the work groups could not meet. I mean, we're all dealing with a pandemic. We understand that. But I think the process of sharing the reports and information will be very helpful. So the first group presenting would be libraries and ATJ. And I believe that Krista Hess will report on behalf of that work.
Okay, thank you. Good morning, everyone. So I'm going to start, and then certainly my co-chairs, Dawn and Jeff, are here as well. And please feel free to supplement or probably more appropriately correct whatever I say. So I think you all got the report electronically, so I'm just going to kind of give a quick Reader's Digest overview. So we really at this point are concentrating on the 30-second PSA that was developed, and that is to make the community at large, the public, library patrons, the court patrons, really aware of the resources that are available through the courts and at the public libraries. And it's going to be an audio only. The script is written. It has not yet been recorded because, for COVID social distancing, we have not yet done that. The script has been translated into Portuguese, Spanish, and Polish. That has been done. And we are basically at the ready to record it. External Affairs is going to do that for us, and they were a huge help with this, so thank you to them. Once we have an ability to get in the room with one another and record the PSA, we will do so. We will have a media campaign that will go out to different media outlets to make them aware of the 30-second audio-only campaign, to ask them to air it. We hope to have accompanying posters. So just a general marketing, gee, we're here and we're here to help, and here are the different things that we can do for you. I think we all sort of acknowledge that going into court is not the most palatable thing, and certainly whether it's jury service or whether it's a court date, a traffic infraction, whatever it happens to be, if we could get people information ahead of time so they can go in and that process is as seamless for them as possible, all the better. And we have amazing law libraries and court service centers to help people do that. So that's what this PSA is hoping to educate folks on. So that's coming. Another thing that we're working on, we had started, several years ago, doing in-person trainings with the public librarians on how to conduct like a hands-on legal research interview and how to make them aware of the difference between legal advice and legal information, which is a very moving target, we all know, and very discretionary. And frankly, when to understand that it's time to refer the matter elsewhere, to the court or to a resource at the court or to legal aid or whatever. So we are obviously not conducting these in-person workshops anymore, but we have since then identified additional areas that really could lend themselves to these workshops in terms of educating the public librarians so they know they can at least start the conversation, as the first point of contact, as a far more comfortable environment for people to walk into and get information. For me, I'd rather walk into a public library and get some basic information. Here's what you need to know. Here's who you should contact, and then sort of send the person on their way. And so we've identified, you'll see on page 4 of the report, those 7 areas, including domestic violence, divorce, employment rights, evictions, foreclosure, poverty issues, and small claims is sort of the larger self-represented party-driven sort of largest case types that we have in the courts and the trial courts right now as areas of interest. So okay, so Lucio just texted, so he's still in the meeting that I hopped out of to come here, so he's still there. So the other area that we are looking at is to create, and this is something Dawn and I don't know, and certainly Dawn can speak to, like the public libraries right now. How open, how many of them are actually open? Are they open to the public? Are they largely shuttered at this point? I wasn't sure, but when they are open and operational fully, certainly creating like a legal corner. We had talked about doing something about having computers, having those computers imaged to have all the relevant links. I mean, and everything I'm saying as I'm saying it kind of presupposes a level of ability, computer efficient, being efficient and effective on a computer, and being able to navigate a computer, English as a sort of a first language. So I understand that I'm making a certain set of assumptions in all of these resources that we're talking about, but the technology I see is one piece. Co-equal, arguably more important piece is the human help that comes along with all of these things in terms of recognizing when a patron, whether be it a public library patron or a court patron, whether you're up here and they're still here, in terms of whether it's a capacity issue or whether it's a language issue or it's a physical limitation, whatever that happens to be. Part of all of this, I think inherent in all of this, is the staff's ability to recognize that and refer the person accordingly. And I think that's something that we all do every day in court. And certainly, I know that the law librarians do that as well. So anyway, creating these sort of passive legal research corners, legal resource corners, where the computers have all the links to ctlawhelp.org or the judicial branch or forms or videos and podcasts and different things in terms of navigating the court system, I think is very important. So that's something else that we're going to be working on also. And then lastly, there exists now a speakers bureau for entities, community organizations, schools to request that a judge go to their respective organization and speak. So we thought, gee, wouldn't it be swell to do the same thing for employees, whether it's someone to come out and talk about the law libraries and all the services they provide, or the court service centers, or ADA, or the volunteer attorney programs, anything that we do that may be of interest. We thought that would be beneficial as well. And it's funny, so we created, by we, I mean External Affairs, created this great publication to request, it's actually on our website, to request a judicial branch employee to come out and speak. And as I looked at it this morning, I realized we may, given the current climate, may want to add a checkbox where the requesting entity can say virtual speaker or in-person speaker, and sort of, have that be an option as well. So as we don't, we want to get the information out there, so we wouldn't want it limited if the person couldn't be in person. So that was just something else I wanted to offer. And Jeff and or Dawn, if you'd like to add anything, please go ahead and do so.
So I just want to touch base on what you brought up. So public libraries were closed to the public, but they were still open virtually, providing services on the virtual platform from March until about June. Most libraries, I would say about right now, 96% of libraries have limited open services by appointment only browsing and things of that nature, but they're still engaging in in-person service appointments, addressing, especially now we've expanded capacity. We just recently got the governor's Everybody Learns grant, expanding capacity. So they are doing appointments for the, excuse me one moment, please.
Jeff?
I think you covered most everything. I would just point out in terms of public librarians, Attorney Chiaretta sent a helpful link the other day to a course that librarians can take at their own speed when they have the time to fit it in. I can send the link to the group if you like.
Great, thank you.
That would be great if you could, Attorney Dowd. Do we have Dawn back? We may not have her back. Krista, I had a question, and I'm going to open up for questions until to see if Dawn Laval can rejoin us. But I noticed the 5th recommendation, which is a terrific idea, for good reason has to be tabled, is the justice clinics in public libraries. It's such a really great, innovative way to, provide access to justice for folks who can't travel or don't have the technology. Of course, it can't be done in the age of COVID, and understandably has to be tabled, but that is also a wonderful recommendation. I hope that your group will, post-COVID, resume that idea.
Certainly. I mean, I think we all are enthusiastic about it. But we actually had tabled it prior to COVID, the inception of COVID, for a number of reasons. And just as an aside, the judicial branch's volunteer attorney programs, the 18 of them that we do administer, are on hold right now as well. I mean, kind of for obvious reasons, but also in recognition of the fact that, a lot of attorneys right now, are just trying to, practice law and, do their thing versus, providing pro bono services. So it really has been a resource issue in terms of them being on hold and not bringing people into the courthouse. But this particular recommendation was tabled largely because, back, and you can see the date on here, a number of years ago, 3 years ago or so, we had done a survey of several of our volunteer attorneys, all of the volunteer attorneys. Those who responded did express some hesitancy in having these programs in a public library for security purposes. There were some hesitancy, the metal detectors in the court, the level of security that is present in a courthouse seem to offer some comfort to everyone, and I find no fault with that at all. That's certainly understandable. And then there was certainly other issue of, well, it's at night, it may be during off hours, and folks have family commitments and childcare issues. So there were a number of reasons that we backburnered that. But I think even thinking about a one-off, like the Mercy Dental Clinic that I reference here, that was the pro bono committee of yesteryear learned about and actually did a survey of the folks who attended, which is a large scale event, having tables with pro bono attorneys present and providing sort of like a large scale fair of people to go in, and whether it's on housing or it's on foreclosure or eviction or small claims, whatever the case may be, having people get legal assistance there. Even if we do something as a one-off, I think that's something we will pursue when resources and time and the public health crisis allow.
That's great. Thank you so much. Let me ask, is there anyone who has a question for Krista, Jeffrey, and if Dawn is able to rejoin us, of course, we'll give her a chance to finish her update.
She's back.
Oh, she is.
Yes.
Dawn.
My apologies. I'm doing actually multiple meetings here. So I just wanted to assure, libraries are open. They are serving the public, particularly in this time of lack of connectivity. We're doing a lot of digital inclusion, which is, we have digital literacy navigators in all libraries that are helping patrons get access to applying for benefits, applying for jobs, applying for, certain types of protections. So libraries are up and running. A lot of our programming is virtual platforms, collaborative platforms. We are continuing to do professional development for our librarians, and we are planning, and we have instituted the practices and procedures for doing that for the near future. So we are open, ready, available. I did chat with Krista and Jeff about continuing with the offerings of legal research and other related opportunities for public librarians, because the need is becoming even more urgent now, particularly as I mentioned with Jeff, particularly with evictions and other urgent legal situations related directly to COVID. So we are willing to work. We can give you more information on how that accessibility can be achieved in this particular instance. Thank you.
Thank you, Dawn. Thank you, Krista. Thank you, Jeffrey. Any questions for Krista, Dawn, Jeffrey, from anyone, any commission members? Hearing none, I again think your work group is unbelievable, and the work and the recommendations you've come up with are just wonderful, and we can't thank you enough for all you do. The next work group is the Modest and Moderate Means work group, and I believe Attorney Nelson will report for that group.
That's correct, Your Honor. Thank you. As I mentioned earlier, Judge Diana, because of his trial schedule, could not be here, and he does apologize. We did issue a written report which went out this morning. So I won't recap everything, but I'll just kind of touch on the highlights. When the pandemic began and everything started shutting down, we actually at first it seemed like it was going to be much easier for our work group to meet, and we started thinking that we were going to be able to try and meet on a monthly basis. But unfortunately, as time passed, I think with the economy, people are just less available during the day to meet. So we've been unable to have as many meetings as we would like. We did meet back in July via Teams, and we discussed a broad swath of issues. At that point, we were still trying to assess where our attorneys were dealing with online access and our clientele who largely does not have the benefit of as much technology as maybe everyone else. And but most of our clients at least have smartphone access to the internet, as opposed to the clients who are unfortunately in the worst straits. But because some of our incubator attorneys are dealing with those people as part of their practice, we were able to talk with the incubator EDs. Jen is online right now, and they provided us with some insight that really didn't meet my experience working with moderate income clients that time. My clients all had email and cell phones, smartphones at minimum. But some of the attorneys were dealing with clients who they couldn't meet in person and who did not have this, and they were corresponding by regular mail, which nowadays is particularly difficult. That led us to try and brainstorm about some things we could do. And as I mentioned in our notes, we talked about whether we could set up something with the library working group to try and do some type of pilot program in a library or two, where clients could go have some access to Microsoft Teams to conduct virtual hearings and whatnot. And we ultimately did have, Judge Diana and I did have a meeting with the co-chairs of the library working group, which I'll touch on in a second. And in our July meeting, Judge Diana also brought us up to speed on some things some other groups are working on in the area of collaborative divorce. Collaborative divorce represents, at least we believe represents, a very large opportunity to serve people of modest and moderate means, as this committee is, our commission is well aware of. Family law is one of the largest issues, our largest areas where people struggle to afford representation. Very few people go into family court because they want to be their own attorney. A lot of them are forced into that position, and the process can be very drawn out and correspondingly very expensive. So Judge Diana had received some correspondence from the Children's Law Center about some collaborative divorce program that they had started putting together prior to the pandemic. And it shows a lot of potential. At the time we met, it was something where they had not anticipated having to go forward with the program on a virtual basis. So that was something they were still working on. And I do expect that in our future meetings, we'll have an update on that and how the online process has worked. As I mentioned in our last meeting, and you may have noticed in the review of the notes, we were joined by attorney Eva Jacobson, and it is our hope that she will be able to participate as a member of our working group. but she is the new director of the Community Law Center, Connecticut Community Law Center, I'm sorry, in Hartford at UConn. She is a byproduct of the incubator program herself, having graduated UConn and then starting up her own practice through this incubator program. And in talking with both Attorney Jacobson and Attorney Ferrante, they provided us with some insights about the what's going on with the incubator attorneys. And I expected that they were going to be very much in a bad way. A lot of law firms that I'm familiar with have really struggled, particularly during this, the early months of the pandemic, had laid off a lot of staff and even attorneys. I was encouraged to see that a lot of the attorneys participating in the incubator program, while certainly affected, were not as affected as some of maybe the more established firms. And I think that probably stems from the fact that they were a little more nimble. Obviously they have the benefit of the incubators, which provides drastically reduced overhead to them as part of the programs. But I think they generally were already experimenting with different ways of meeting with clients and getting work done, which isn't to say that, things have gone, perfect for them at all. And I hope that we'll have an update at our next meeting, which is coming up next week. But one of the interesting things, and Jen can chime in here certainly to the extent that she wants to, one of the issues that we were trying to look at then is how the pandemic was going to affect the recruiting aspect of the incubators. And I don't know the answer to that. And if Jen has any information, I'll invite her to share that when I'm done yammering. As far as going back to the library pilot program, we have struggled to meet as a group since Judge Diana and I had our meeting with the co-chairs of the library working group. At this point, with everything kind of swinging back to more of a stay-at-home type of practice, Judge Diana and I decided that it's probably best to put that on the back burner for now and reassess the working group's priorities towards the incubators and those attorneys to see what we can do. And we do have a meeting coming up next week to kind of reassess that. So that's kind of my spiel. Jen, if you have anything you'd like to add, please feel free.
Sure. Just with regard to recruitment, we were also, very concerned about who would be able to apply to our program this go around. Our third cohort starts in January. We did not have many applications, but we had very high quality applications, and they were all from experienced attorneys, not attorneys coming fresh out of law school, which you would expect. So we will have a small class, but we will be going forward with the program this starting in January, and our door is still open. Our deadline is December 15th, so you never know, we might be a little bit bigger than we are right now. So thank you.
Thank you, Attorney Nelson and Attorney Ferrante. That's terrific. And I should point out, yes, I did sort of delay making the request for Attorney Ava Jacobson to join the working group. It is our hope that she could also possibly join the commission. Of course, those decisions are made above my pay scale, but we will work on that and try to get it done. I understand you have a meeting next week. I can't promise, but if I could see if that appointment can be made, at least to the working group, if not both the working group and the commission, I'll work on that and let you both know.
Your Honor.
Yes.
I'm sorry, I didn't mean to interrupt you, Your Honor.
No, I just wanted you to know that I'm on it. And I will be speaking with, of course, Judge Bizzuto. I'll be speaking with her and the Chief Court Administrator, Judge Carroll, and we'll work on getting that done. And so I think it's important to have the representation of both incubator programs in Connecticut, and you're right. So we'll get that done.
Thank you, and everyone certainly understands that you and the entire branch have quite a bit on your plate. Attorney Jacobson has been, gracious enough to just attend our meetings as a guest. So I don't think there is any, acute rush. I'll leave it to you and the branch to prioritize your time as you see fit. I certainly don't need to push that.
No, there's there are a couple of issues around just, there are changes in staffing, of representative groups on the commission that we need to address. And Attorney Jacobson is definitely, she would be replacing the person who was the former director of the incubator program. So that's a designated seat on the commission. We really need to kind of address that. So we will. I wanted to assure you that it even before this, prior to the meeting, I was aware of it. We were discussing it, and we'll get to it.
Thank you.
Any questions for the modest and moderate means and HEJC group? And again, I thank you so much for meeting regularly, for coming up with these wonderful ways of increasing access to justice, particularly for the population that often falls through the cracks, the modest means, folks of modest means. The idea of increasing that in the family law area is amazing and terrific. So thank you. Any questions for Attorney Nelson or Attorney Ferrante?
I have what may be a comment for you. I was really interested in your remarks about collaborative law and using that as a lower cost approach to divorce. And I unfortunately, I cannot provide a citation because I have a feeling this research was never published. But I am aware of some research that occurred up in Boston at the Boston Law Collaborative. David Hoffman, who's a very well-known mediator up there, actually looked at just a sort of a sampling of divorce cases handled through their law firm, and did discover that mediation was actually lower cost for the clients than collaborative law was. But his theory was that it might be that collaborative law was being taken up more by couples who had more complex financial lives, so there could be a sampling bias there. But I just wanted Jennifer and Chris, to know that David Hoffman had done some comparative work on that. It might be worth looking into to see whether he's updated that research at all, or if he has theories for how, if at all, the costs of collaborative law approaches can be kept down. And, if he still is at all concerned that it may, in a way, be more expensive than mediation. Both of them were less expensive than litigation, though. So that's the good news. I just thought I would throw that out.
Thank you, Dean. And I think it is it's a point well taken. And I won't go into all the details of the program the Children's Law Center of Connecticut is doing, because it's not our program. We want to see if we can help them or at least make their program more accessible to people, but it is their program. And incidentally, they've had a large amount of help from Quinnipiac interns. But what's notable about it is that they're really bringing in the custody element to this. And I think the dean's comments are exactly right. I mean, mediation is probably the preferred way to resolve, the disputes, but that often is not possible because of greater conflict. And so, that's where hopefully the collaborative, divorce will fit in. But I did take down the notes, Dave, and we will look to see if we can find any of the research by Mr. Hoffman, because Judge Diana particularly is very interested in the collaborative divorces, and certainly any alternatives that are there. He is sitting in regional family court in Middletown, so it's very important to him because he sees only the highest conflict of cases. But we will absolutely look into that.
Thank you, Dean Brown and Attorney Nelson. And I think this illustrates one of the wonderful aspects of having our commission meet quarterly. And the purpose of our commission is to make sure that we are aware of all the resources and possibilities that exist that we can tap into and know what sort of every corner of the state, every part of the state, whether it's the law schools, the libraries, we have tremendous resources. And if we can help each other by directing, and sharing what we're doing, it's wonderful. This segues nicely into the next working group, which I do want to get to because I know each one of the deans of the law schools agreed to present. And I want to thank Dean Brown. She did. She was the first to tell me that she could present. Dean Fisher from Quinnipiac Law was not able to attend, but asked if any of the other members of the work group could present. And Attorney DiMiola, Dean DiMiola, agreed to present on behalf of UConn, but she does have a conflict and she does have to leave. And so, Dean Brown, if you don't mind, I would have Dean DiMiola present first, if that's okay with you. And I know Dean Ahmad also said he would present. Basically, they're going to tell us what their law schools are doing, how they're coping with COVID, how it might relate to access to justice, or it does certainly as well. Is that all right with you, Dean Brown?
Yes.
Thank you. All right. Thank you. And I'll start first by asking Dean DiMiola to make a presentation on behalf of her law school.
Thank you, Jessica, and thank you, Dean Brown. I appreciate you accommodating my calendar. Not that yours isn't as busy or busier. So a few things. UConn Law School began telecommuting on March 23rd and essentially shut down all operations until we can get a better handle on where we were, what the institution at large was going to do, and how we could implement safety and public health measures ASAP. That did mean that the CCLC doors, Connecticut Community Law Center doors, shuttered, and attorneys did not have access to the buildings. The same was true for our clinics. As we sort of learn more about the virus and we receive guidance from the university and the state, we could not open our doors again to the CCLC because they were members of the public. So even though the attorneys have office space on our campus, they're not considered staff, faculty or students, and so they could not, again, have access to the building, which did make it a challenge. And, it was difficult. We did arrange for people to come in and pick up their files, but that was a challenge that the attorneys had to tackle. And as Attorney Nelson pointed out, they're pretty nimble, and they managed, I think, better than many of us in terms of transitioning to telecommuting or remote work. And there were several benefits that Eva did report out to me about that experience. One, that the transition was easier for those attorneys. And despite a number of challenges, including client frustrations around cancellation of court dates and no guesstimate as to when those courts, when the dates would be rescheduled, outstanding and pending matters caused stress and anxiety. But that transition also meant that the costs of representation went down, both in terms of the number of hours spent. So, attorneys may spend half a day in court. That was no longer necessary when most of the proceedings, Eva let me know. We're about an hour and a half, and that looks very different from a billing perspective. It also meant that those clients were saving money because they didn't have to take the full day off from work, and most of the clients that they have don't have paid leave, and so it was a tremendous value that clients were able to, instead of taking the full day, log in for an hour and a half, which was a benefit. Yes, every attorney experienced a drop in caseload, but again, things seem to be picking up at this point, which is nice. We are prioritizing, we were able as an institution to prioritize bringing and creating additional clinic space for our in-house clinics for our faculty and students. And they were the first group to get access to the buildings. Most didn't want to, most clients didn't need to come on site, but we did create we created an office space so that clients could come in and use technology if they needed to. They had to be supervised by either a student attorney or by one of the clinicians. And that seems to have worked pretty well. We continue to prioritize them in our space. We are looking towards the spring, so we'll have about 5 or 6 classes in person in the spring semester. Clinics will remain on site, and then we're looking at prioritizing bringing back CCLC in some way. It does require the university to lift their guidelines, but we're hoping to at least have a bit of space open for them and their clients. I could send Eva's report out to the chairs of the committee so that you have that for your records. I'm happy to share it with the full committee if people are interested as well.
Great, thank you so much.
Thank you.
I know that you have to go, so let me ask, are there any questions specifically for Dean DiMiola? And Dean DiMiola, we'll share with you later on in the meeting. We're going to hear from Judge Bizzuto and Krista Hess and Ty Erickson. Hopefully she also has a conflict, but we're going to hear about some of the initiatives and things that the branch is doing about remote access that you may want to catch up about later, and also the national conference. Let me turn it over to first, let me ask any questions for Dean DiMiola from anyone.
Can I ask one question? I was curious about, so thank you, that was really informative. I was curious about if you could say a little bit more about clients being able to use the technology that you made available, and just kind of what that looked like and what the technology uses were, whether that was for participation in virtual hearings or for other means.
So it was for virtual hearings. Am I off mute? Yeah. And to fill out some forms that were converted to electronic PDFs by clinicians or their students. It was interesting, you know, many people don't have printers at their homes anymore because they spend so much time at the office, and so printing out documents became challenging. And they used to send those to any clients who had the capability, but they have a growing number of clients who don't have that capability. Some were using the technology for translation services. Many of the clients don't have smartphones, and so there are a variety of different ways that the students and the faculty use that technology to engage and effectively communicate with clients. And it was a basic Dell computer, state issued.
Thank you, Dean DiMiola, Dean Ahmad. We will be covering, Dean Ahmad, one of the focuses of the national conference was how to provide technology to folks who don't otherwise have it in the age of COVID. And I know that that's an issue we're going to be talking about again throughout the meeting. Let me turn it over to Dean Brown and then to Dean Ahmad, who will provide their reports. And again, thank you, Dean DiMiola.
Thanks. Well, I think Quinnipiac's experience is in some ways quite similar to UConn's, very much in that same mode of moving into remote mode and having to do everything remotely starting in mid-March. sort of transitioning over the summer. And in mid-August, we were able to open in a kind of hybrid mode with some on-ground teaching and a lot of remote teaching as well. Unfortunately, Quinnipiac University has had a very strict no visitors policy, which is just anyone who is not a current faculty member, staff member, or student. And that, to my knowledge, has included clients in the clinic. The clinic remains busy, but if they're meeting with a client, if they need to meet with a client in person, they're doing it off-site, finding other places to do that. And I can provide further details. I don't have them with me right now, but I can certainly get more detail about that. And I'm very interested to hear that UConn has found a more flexible approach to that. So that may be something that we'd want to push for at Quinnipiac as well, especially because I think we could give them a sort of even alternative access to the building using a different route into the building that could reduce any risks of infection. The one thing I did want to share with the group, a couple of things we've done that are COVID related or access to justice related that may be of interest to this group. And one involves also Yale, and I'm sure Munir will have more to say about this, but it's not so much in the state courts, but one of our clinicians, Sarah Russell, and students that she worked with was quite active in the class action, a coalition of lawyers and law clinics that represented men and women who were incarcerated at FCI Danbury to push for a review of the medically vulnerable prisoners, for actual release to home confinement. And that was successful, and we're very excited about that, but that certainly was very time-consuming work that, really grew out of COVID. The other project that we're about to launch is in partnership with the Connecticut Department of Housing and grant funded through the CARES Act, where we will our students will be providing mediation services in homelessness prevention and sort of catching some cases at an earlier stage than even they're caught in the homeless diversion program. So that's something that is really about to launch. The MOUs have all been worked through, and so that'll be housing related mediation that we hope will be helpful in there. That's my report from Quinnipiac.
Thank you, Dean Brown. Let me ask, are there any questions for Dean Brown's report? And let me just say, it's so exciting that the two programs you announced, the housing issue, I can tell you at the national conference, the huge focus is on housing, because of course, if someone loses housing, they lose everything, right? All the other issues, and it's such an area of impact under COVID. So that's really exciting. And if you don't mind reporting at our next meeting, sort of how the program is going, that would be terrific. Any questions for Dean Brown, or comments, I should say? Seeing none, thank you again, Dean Brown, and thank you for reporting on behalf of your work group as well. And let me turn it over to Dean Ahmad for his report, and thank you again, Dean Ahmad, for reporting as well.
Of course, Your Honor. Thanks so much for the opportunity. So, some of what I have to share is really resonates and is quite consistent with what Dean Brown just shared about Quinnipiac in terms of how the law school at Yale is operating, the constraints we're operating under. But I want to cover those a little bit because there are some things that we've done that I think have been effective, and there are a number of constraints that we've run into that I want to make sure this group is aware of, because there may be opportunities for some advocacy around them moving forward. So, like Quinnipiac, the university, Yale University, has a very strict policy which applies to the law school of no visitors. And we have been able to negotiate with the university for a limited carve-out for for the clinics, but it's a fairly cumbersome process. Essentially, it's a case-by-case approval. So each time a student or clinician wants to meet with a client on campus, they need to basically go through an approval process with me, which includes kind of laying out a protocol for how the person gets into the building, how long they'll be meeting, what room they'll be in, what the purpose of the meeting is, assurances around social distancing, and that is then combined with very strong recommendations that we give to our students about the frequency of testing that they should be availing themselves of. We're very lucky that our students have easy access to testing, and so we have built in recommendations about how frequently they should be tested in advance of and after an in-person client meeting. But suffice it to say, it's a pretty cumbersome process. I think that since the start of the semester, we probably have had less than 10 on-campus meetings with clients, whereas we would probably have that number of meetings with clients, in the course of a couple of days in ordinary times. There are some things that we have tried to, and I should add, the same restrictions essentially apply to off-campus meetings, and so we have had some off-campus meetings or participation by students in off-campus events, and each time, again, we've required them to kind of submit a written protocol for our approval. In some ways, the university is a better setting than off-campus. One of our concerns, and this was something that we presented to the university administration to get a carve-out in the first place, is that if our students were not meeting with clients in the law school building, they would, and not having access to other spaces in the community, they would end up meeting in the Dunkin' Donuts or somewhere else where the public health consequences would be far more severe than in our building. One thing that we have tried to do is with clients who don't have access to technology, we have been lending technology, and so we have a handful of iPads that we have been lending out on a rotating basis. It's not that expensive. On the other hand, it's not just the iPad. It has to be an iPad that has cellular service, because if our clients don't have the technology, they likely don't have wireless access either. But we've been using that for communications and in cases where we need to prepare clients for testimony or depositions or things like that. I think it's kind of too early yet to know how successful that is, but it's something that we've been trying out. I'll say that some things have worked better than I thought they would. Hearings in court, in federal court in particular, have been relatively seamless. Taking and defending depositions has actually been a lot easier than I imagined it might be. But those are things that had been put on hold for, I think, the first 3 or 4 months of the pandemic, and then we started in September, essentially resuming those practices, and they've gone reasonably well. One topic I did want to flag for this group has been access to incarcerated clients and in DOC facilities. And so for the reasons I laid out about the university's constraints, we're quite limited in our ability to send either our faculty or our students to meet with incarcerated clients. And we have done it, I think, in 2 instances the entire semester. It was very, very cumbersome. The approvals we had to actually kind of work through at a higher level for each one of them. It required getting PPE that we didn't previously have. And there was just a lot that was involved in getting people in. I am aware that some of the DOC facilities have video conferencing capabilities, and that they're using Teams and maybe other platforms for general visits. What my colleagues report, though, is it's not clear that those are being made available to attorneys, or that the use of those platforms are available for confidential attorney-client communications. And so I know that DOC is not part of this group, but to the extent that the judiciary has an ability to kind of engage with the relevant kind of counterparts at DOC, I think this is a really big issue. It's very difficult now for attorneys to go in for in-person meetings. When we talked about this with our environmental science people and described to them what the physical layout was, they essentially prohibited us from doing it unless, we could establish an overriding professional responsibility that had to be, it required us to go in. But given that the rooms are small, the ventilation is poor, it's unclear what the testing protocols are within the facilities, it does put a very big premium, I think, on increasing access through video conferencing and ensuring that those are confidential communications so that access to clients doesn't come at a trade-off of maintaining our duties of confidentiality. So anything that could be done through this group on that issue, I think would be very important and really help to meet the access to justice mandate of the group. I guess I'll just, before closing out, I very quickly just mention some of the work that we've been doing that has been COVID related. So our housing and foreclosure clinic has continued to represent clients. The state and federal moratoria on evictions obviously has lessened the load, but what is reported to me by my colleagues who teach in the housing clinic is that the short calendar, I think, had been suspended and resumed, and I believe now for property and foreclosure cases will resume on December 7th. And this is another technology, a place where kind of the technology access and the physical access to buildings kind of intersects, because my understanding is that clients who, no one is going to court, so things are being done remotely, but the expectation is that lawyers make their offices available for clients to then use the video conferencing capabilities to communicate with the court. And because of all the difficulties that we have in gaining access to the building or providing access to the building for our clients, that's creating quite a bit of difficulty for our housing clinic. Nonetheless, we're trying to work that through. I'll just mention briefly that our Community and Economic Development Clinic essentially spun off a small business in a time of crisis clinic that has done a lot of transactional work in support of small businesses and particularly minority-owned businesses since the pandemic began. And that's been focused on education around PPP and trying to ensure equitable distribution of disaster relief and community-based health resources in and around New Haven in particular. They've also been advising and representing commercial tenants seeking to renegotiate their leases or to avoid eviction. So there's been a range of activity that they've been engaged around that. And then the last body of work that we've been doing has been around detained and incarcerated individuals. And as Dean Brown mentioned, two of our clinics were collaborating with Professor Russell at Quinnipiac and with the ACLU in the class action at FCI Danbury. We've also been counsel with some folks out of Boston representing immigration detainees at a facility in Massachusetts, which houses Connecticut residents who are detained by ICE, and have been successful in obtaining the release of a number of people to home confinement, and that litigation is ongoing. So that's kind of the scope of work we've been doing. But again, I think that it's through the course of that work that we have encountered and identified some of these access issues that our clients are having.
Thank you, Dean Ahmad. And I do want to first thank you for sharing with us what the law school is doing. There are two things that I want to do. One is first acknowledge that Attorney Saxton raised his virtual hand, so I'm going to turn it over to him for his question. And I will, on behalf of the judicial branch, the highest official with us today is the Deputy Chief Court Administrator, Judge Bizzuto, and I, of course, would defer to her if for any thing she'd like to say with regard to your the concerns you raised about DOC visits. So Perhaps I'll ask Attorney Saxton to ask his question, and then if it's okay with you, Judge Bizzuto, I would defer to you if there's anything you wish to comment or say, and then open up for questions otherwise for Dean Ahmad.
So thank you. And Dean, I just want to both amplify your concerns. We do a fair amount of work on behalf of OCPD as assigned counsel representing incarcerated individuals in their appeals. And we share your concerns. The two additional points I would make is that, one, in the past, we have asked to use video conferencing to have private client communications, and they have always been open to that. The problem had been that before the pandemic, the technology that they had was so antiquated that it wouldn't interface with the video conferencing equipment that we had. So we were unable to do that. And the only other point that I would make would be, and I think Judge Bizzuto will be able to speak to this, more fully than I can, but that it is my understanding that DOC is moving to Teams, and that I think part of the idea there would be that there would be that availability to have those types of confidential meetings. But no, I agree. I think it's a really important issue. And I just want to share that I think they've been open to allowing us to do that and have tried to make that work. We just had incompatible equipment in the past.
Yeah, so I could just add to that. I mean, since we do hundreds of arraignments and criminal proceedings each week, we've been in regular, almost daily, if not weekly, communication with DOC to coordinate all those efforts. And Attorney Sexton, you're right. They were and still are in a lot of locations on the Cisco platform, and are in the process of converting everything over to Teams. And they went a long way, but then hit pause for a little while because they were rapidly trying to set up these Teams conferences for family visitation. So they kind of put the expansion with respect to the branch on hold for a short period of time. But the intention is to convert all of that over to a Teams platform where they don't even have to bring the prisoners into the building anymore. Right now with Cisco, they bring them to the building. The prisoners are kept in lockup, but can communicate with their lawyer, bail, the court by way of the Cisco platform that's mobilized and utilized within the courthouse. But to even avoid having to transport prisoners to the courthouse, they're moving over to the Teams platform. I don't today have the estimate as to when that conversion is going to be completed or how far along they are. But, scheduling is done regularly. And I know, of course, the PDs are on their schedule all the time. They have, master schedule for Cisco, master schedules for Teams, and, have been accommodating those requests for the lawyers and obviously also for the court when it's either, our proceedings post-arraignment where we have a criminal proceeding that involves an incarcerated prisoner.
Thank you, Judge Bizzuto. Thank you, Attorney Saxton. And, Dean Ahmad, if I'm sure Judge Bizzuto or Attorney Saxton can maybe assist how they go about scheduling how Attorney Sexton tries to schedule those video conferences and perhaps get more information. I do want to keep the meeting going. We have about 50 minutes left. We still do have quite a bit to present, and in fairness to all the working groups, I do want to move it along. So let me just ask, are there any questions for Dean Ahmad? Or comments? Seeing none, again, I thank you, Dean Ahmad, and I will ask if there's anything we can assist beyond today's meeting, let us know as well. The next work group is the General Pro Bono Work Group. I want to say that Judge Harmon had he co-chairs that with Attorney Ogilvie. He had every intention of attending today's meeting, but he had a court proceeding that he thought would end yesterday, but the proceeding continued to today. And so he apologized, and Attorney Ogilvie, I thank her. She's his co-chair on that committee, and I'll turn it over to her for her report.
Thank you, Your Honor. We have a very quick report. Like some of the other working groups, we have not been able to meet regularly. Our group is meeting on December 17th, and we will be trying to come up with our plan for 2020. We acknowledge and understand that there will be or should be increased demand for pro bono services, so even higher than normal need for attorneys. So we will be tackling that issue, and also the issue of the challenges with getting pro bono attorneys in the light of COVID. We have heard from a lot of attorneys who are not even coming into their own offices and workplaces that it's harder pro bono case, particularly if they're going to have to do it in person. So that's a very real challenge. And we've also heard that same concern and an issue voiced by some of the legal services organizations. So we're going to have to think really hard about ways that we can get attorneys to be able to do the pro bono work that they want to do, because we're going to be remote for a good 6+ months. So those are the main items that are going to be on our agenda. And then also we have some of our working group members are on pro bono committee or leaders at CBA, and they have recently circulated the CBA Gives email. I don't know if everybody had the opportunity to see it. It went out this week, but if the link, if you click on the link, it talks about the CBA Connect site. And that's where lawyers can be connected to opportunities to do pro bono work with legal service organizations. So CBA really needs help in getting the word out about CBA Connect. So that is something that is important, and we said we would do with them as well to try and really encourage. But that is generally the topics that will be on our agenda for next week, and we welcome any other thoughts and issues that you all think our group should be addressing.
Thank you, Attorney Ogilvie. And as it relates to the Connect, I know Attorney Thomas in your work group had asked if I or someone in the branch would agree to do a post something on the website or do an interview through External Affairs or some kind of recording about the program. I know I'll Judge Bizzuto and Ty Erickson, Krista Hess can work with you and Judge Harmon and External Affairs to see what the branch can do in terms of getting the word out as well. If it's not already a link on our website, they also do podcasts and things that help educate the public about the service. So I will follow up on that as well. Any questions for Attorney Ogilvie and her general pro bono work group in her report? Seeing none, again, I thank you, Attorney Ogilvie, and also very excited about the other recommendation your group was working on, which is a concise report of all the services available, all the resources available. That will come in very handy post-COVID particularly. So that's terrific. Thank you. Thank you. The next work group is the Appellate Pro Bono Work Group. I just want to mention that Judge Moll had intended to attend the meeting. She too had a conflict and could not attend. She communicated with Attorney Saxton, who's on that work group with her. And I believe Judge Bright is as well. And so I would defer to him as well if he wishes to add anything. And of course, as the chief judge for the appellate court, of course, I would defer to him also. But Attorney Saxton is going to report on behalf of the Appellate Pro Bono Work Group. Attorney Saxton, I'll turn it over to you and to you, Judge Bright, as well, if you wish to make a report.
So obviously, I too will defer to Judge Bright if he has anything to say, and if I say anything that doesn't jive with his memory, I'm sure he'll point that out. Judge Mall, Judge Bright, and I did meet previously to discuss some of the ideas for how we might approach a sort of appellate pro bono program. And my recollection of that meeting was that some of the ideas that we had talked about, one, we discussed sort of how to identify cases where getting a pro bono or low bono appellate attorney involved might be useful. Some of the ideas that we had talked about in that regard involved using PAC judges who currently identify cases that should go perhaps directly to the Supreme Court to see whether or not they could help identifying some of the cases that might benefit from the involvement of a pro bono attorney. Obviously, part of the problem with that, particularly right now, is that those PAC conferences, PAC stands for pre-argument conference, which are sort of settlement conferences that go on before the briefing and argument in an appeal. Those have been suspended as a result of the pandemic. They're usually handled by senior judges and/or JTRs. So there are also some of the, either usually in the past at least, Supreme Court justices who are now JTRs at the appellate court who have helped to identify cases that might get transferred to the Supreme Court. We had thought that they might also be a source of identifying some of these cases. Once they're identified, we had some discussion about how the courts might get a pro bono attorney involved, both in terms of organizations that could provide a list of available attorneys that would be open to accepting such work, but then also in terms of what the process would be, given the different stages of a potential appeal, because obviously if the need for that sort of representation isn't identified till after briefing or until after perhaps even argument, the question would be whether the court would use some sort of inherent supervisory authority to order supplemental briefing, and whether it's the appointment of pro bono attorneys or what have you. We discussed some way to maybe do that, but I think the thinking at the time was at least to try and sort of start on the smaller side, where attorneys would be involved in drafting some sort of supplemental brief, something like that, rather than taking on the entire appeal at first. I think it would be great to get there. I don't know that we're going to be able to start there. And obviously, in line with that, it would come the idea of perhaps having some sort of a limited appearance for appellate purposes. We have limited appearances, certainly, in the Superior Court and then on the family docket, you see it most frequently. And that may require a rule change at the appellate rules to facilitate, but that was something we had also talked about. At the same time, as is true of many of the other subcommittees, we have not had the opportunity to meet recently. And in my conversation with Judge Mall yesterday, the plan would be to try and find a time that would work for the three of us, Judge Bright, Judge Mall, and I, to get together again, maybe in a Teams meeting, to sort of, build on some of the ideas that we had discussed previously, so that we could give a little bit more of a full report at our next meeting. But that is, I think, sort of where we are. And I would obviously just defer to Judge Bright, if there's anything he wants to add or amend as to what I just said.
Sure. So just a couple of things. I think Jay did a good job summarizing where we are. But what we're trying to do to address some of the challenges is, Jay mentioned the pre-argument conferences, the PAC conferences, which are the settlement of conferences that take place at the beginning of the appeal before briefs have been filed, because after the PAC conference, the court will often set a schedule for the briefing where the parties will agree to it at the PAC conference. That involves all civil cases except for foreclosures, and it does not involve criminal cases or habeas corpus cases for the most part. I suppose condition cases could go to a PAC conference, but I don't think they normally do. But with us not using JTRs, PAC conferences really haven't gone forward. We are proposing a rule change to the appellate rules that would allow the Chief Justice to designate certain Superior Court judges to conduct the PAC conferences. And if that's done, then we would have the ability to have these PAC conferences and have the recommendations if the case doesn't settle as to what goes to the Supreme Court, and then potentially also have a recommendation for a pro bono attorney to get involved. The issue, though, with that, where we see self-represented parties in civil cases tend to be foreclosures, which are not going to be part of the PAC or not part of the PAC conference unless both parties agree there's a value to it. And if they do, then we can have a PAC conference. And if that's the case, we might be able to get a pro bono attorney in if the defendant wants a pro bono attorney. We find in a lot of the foreclosure cases that they're not interested in having a pro bono attorney. Family cases are the other ones, and that, again, might be a possibility. The other process that Jay was talking about is the ready review piece, which happens much later in the process. So if we identified a pro bono attorney at the PAC conference and need for one and got an attorney involved, they then would handle the whole appeal, which would be filing the brief and then arguing. At the ready review process, that's when we review cases to see whether they should be transferred to the Supreme Court. As part of that ready review process, which is now being done by the sitting appellate judges, because again, the JTRs who typically did the ready review aren't available to us. So we are now reviewing those cases. We could review those cases, and whether we determine the case should get transferred or not, we could say this is a case that would benefit from having a pro bono attorney. Now, at the ready review process, all the briefs have been filed. So at that point, if we identified an issue in a case that was not adequately briefed by a self-represented party, we could then reach out and have a more limited role for a pro bono attorney to file a supplemental brief to address a particular issue. Because oftentimes we'll send out an order saying that the parties are ordered to file a supplemental brief addressing the following issue within 30 days and 10 pages per side. So that would be a more limited role for the pro bono attorney. But it means developing panels of pro bono attorneys who are comfortable with us contacting them and saying, okay, here's an issue for you. Are you willing to step in and take the whole case, or at least meet with the person about the whole case? Or are you willing to talk to this person about filing a supplemental brief? In terms of the limited scope representation that we have in Superior Court, it would be a little bit different at the appellate court level, because what we do in the Superior Court is say you can file a limited scope appearance for a particular step in the process, not as to a particular issue. So if it's an injunction hearing or a discovery hearing, you're in for that particular part of the process, no matter how long it takes. We're trying to figure out on the appellate level whether we can do it that way or whether we would have to provide an ability to file a limited scope appearance to handle a particular issue identified by the court. So that's a little bit of a difference from how we're doing on the Superior Court, and those are kind of the details we have to work through. And we're going to continue to work at those things, but until we kind of get through this pandemic piece, I think it's going to be hard to develop a panel of pro bono attorneys who would be willing to step in and who would feel comfortable communicating with a litigant on a relatively short notice to figure out whether they're going to step into all or part of the appeal.
Thank you, Judge Bright, and thank you, Attorney Saxton. And what your committee is experiencing, your work group is experiencing, I think, is what we all the work groups have this common theme, which is that in light of COVID, there are certain restrictions and certain inability to pursue some of these initiatives, but they're still great initiatives. And we thank you for your group for doing that. Any questions for Judge Bright or Attorney Saxton, or comments? I see none, and I again thank you, and we look forward to the future work of the work group and your report on some of these initiatives. The next work group is the video conferencing ATJC work group, and I'm going to turn it over to Krista, and she's going to begin the report from that work group, and she will then introduce Judge Bizzuto and Ty and Stacy, who are going to report on item 4, because it relates to item 4, measures undertaken by the judicial branch. And I thank them, and I think you're going to hear about some really interesting things that they're doing. Krista, thank you.
Okay. Thank you very much. So I have the easiest part of this, which is 2 seconds, because the Access to Justice and Video Conferencing Group that was formed a bajillion years ago, when God was a boy, really has sort of run its course. I mean, it was set up, I don't know how many years ago, a long time ago, to try to increase, this novel form of communication between the bar and self-reps and the court. Instead of bringing everyone into court in recognition of lawyers with multi-jurisdictional practices, and we're a small state, you can get end to end in 2 hours. Then individual calendaring came on the civil side. There were all of these status conferences and scheduling conferences and trial management conferences ahead of trial. So we thought, gee, wouldn't it be swell if we could do these conferences by video? And so it started out with that and sort of limped along, as folks on this commission know, and then morphed a little bit into pro bono, which we are actively using video conferencing for pro bono, and in New Britain and I think Waterbury, I believe, but it really never went anywhere. It was the thing. It was like e-filing. Not until e-filing became mandatory did it really take off, interestingly enough. So when it was voluntary, it was like, geez, I'm more comfortable doing it the old-fashioned way. So we never made, obviously, video appearances mandatory, and then flash forward to where we are now. So the video conferencing work group, I would suggest, and maybe not for this meeting, really be morphed into a remote justice working group that really takes all of the initiatives and contemplates all the different platforms that the branch is now administering business, whether it's on the record or off the record proceedings with DOC, Teams, Cisco, whatever it happens to be, and encompasses all of that, because it really no longer is what it was originally intended to be. So that, having said that, Judge Bizzuto, I don't know if you want to start the discussion on the initiatives that we've undertaken as a result of COVID.
Sure. Thank you, Krista. And it's, interesting to note that at the last time we all met together in a room in person in February of this year, 2020, Krista, I think you reported out from your group that, you're really hopeful and wanted to pilot video conferencing and civic. And it's just amazing that, 30 days thereafter was declared, a state of emergency, and to where we are today, really, with video conferencing just being a regular part of our business. So it's really what the progress that you guys have made in modernizing the judicial branch in a matter of months is really, truly amazing. So I have a lot to report. These guys put all this stuff together for me. So I'll go through it as quickly as possible because I know time's running out. But when we I last reported in June, we were in the infancy of conducting virtual proceedings on the Teams platform. And now across all divisions of the Superior Court, civil, criminal, family, juvenile, virtual evidentiary hearings and courtside trials are being conducted each and every day. And we currently have 100 virtual courts on our remote platform, and we are planning on adding an additional 30 virtual courts in the very near future. I recently attended virtually a conference, and a presenter made a statement that has really stuck with me ever since I heard it. She said, and I don't recall her name, but she said, as we always hear, we're all in this storm together. But she pointed out that we're riding in different boats. And I think that is really very much true when we talk about the justice system, and even more importantly, the work of the commission and the focus of your efforts. So in the branch's effort to ensure access to remote proceedings, we are creating what are called remote rooms. Sometimes people refer to them as kiosks, but we're calling them remote rooms because they are actually rooms in each one of the judicial districts operating courthouses. And these remote rooms are designated rooms equipped with technology that can be used by a litigant or witness who does not have internet access or access to a computer or a tablet or a smartphone. And each room will be equipped with a device with a video screen that will be linked to the team's remote justice platform and will allow a party or witness to participate in a civil, family support magistrate, or housing court hearing or trial, whether it be on the record or off the record, whatever the proceeding may be, they'll have use of these remote rooms. And for criminal and juvenile matters, rooms have also been established in our GAs and our juvenile courts where defendants and witnesses can participate in court processes using these out rooms. We continue to expand and add features as they become available to our virtual platform. A recent one, and with many, many thanks to our very own attorney, Jay Sexton, since this was all his idea. Effective November 16th, documents that a party intends to submit as evidence at a remote hearing or trial in a civil or family matter are now submitted as electronic exhibits through e-services. You know, this was really a pressing issue and a big question for the practicing bar and litigants. You know, how do we get our exhibits to a closed courthouse or not a closed courthouse, or a courthouse where, you know, we really aren't operating from any longer. And some time ago, Jay brought this idea to our attention. We got IT working on it immediately, and it was just recently rolled out. I've had several conversations with many of our judges, and certainly our chief administrative judges, Judges Abrams and Judge Albus, and they said the process is being widely used and is working very well. I'd be happy to hear any comments from any lawyers who've had experience with it to see how that's working, but it was a huge improvement to the platform. In housing, the summary process cases, mediations are being conducted remotely via the Teams platform by our staff mediators. If an agreement is reached, housing mediators are able to prepare stipulations for review electronically by the parties using a stipulation form specifically developed for that remote purpose. A process has been developed in cooperation with CCADV to provide applicants filing restraining orders with the ability to file them electronically. Both TROs and CPOs, the civil orders protection from all JDs, can be emailed to a newly created shared mailbox or faxed to a newly established centralized fax, thereby eliminating the need for applicants to come to court to file the applications. We have an online dispute resolution process for motor vehicle infractions, which allows an individual who received an infraction and enters a not guilty plea to provide additional information or documentation electronically to be considered by a prosecutor. The prosecutor may make an offer, which could include reduced fines or an option to accept different charges. And if the offer is accepted, a plea of no contest enters, and the agreed upon fines or fees can be paid online, eliminating the need to come to the courthouse. For 2020 this year through December 1, 55% of the defendants have requested participation, which almost doubled from last year, with 71% of the prosecutors accepting the proposals. So it's worked effectively, and the program provides remote access to a very high volume area of court business and has had a substantial impact on reducing the number of people who would otherwise have to come to the courthouse in order to negotiate with a prosecutor and or pay a fine. An online dispute resolution pilot program in Hartford, New Britain, and Fairfield judicial districts was rolled out December 1st, just this week, for newly filed small claims cases. You know, of all the work or backlog that we've experienced, the highest volume of backlog has been in the small claims area. So this would allow for the resolution of cases through the voluntary remote participation in a simplified court process. A judicial branch mediator will be assigned to conduct a remote mediation to help the parties settle. And if they do not settle, a remote hearing before a judicial authority will proceed. So that was just this week, and we'll keep you posted on the progress of that and hopeful success and expansion into the other judicial districts. Also, in an effort to encourage self-represented parties to electronically file, which is a huge help we've learned through this pandemic. The branch has simplified the process to gain access to e-filing, relaxing the requirements for verifying ID for self-represented litigants seeking access, and eliminating the notarization requirement. So as of October 30th, 1,854 self-represented parties have been approved for access to e-services. And this is in contrast to the same time period last year, where we had 742 self-represented litigants who were given e-filing credentials. So it's more than doubled. And as for the last piece to report, which is really a huge new initiative, I'm going to turn it over to Stacey Franklin so that she may report on this initiative, in that she's been instrumental in planning this initiative and also seeing it get off the ground. So Stacey, I'll turn it over to you to report on our call center.
All right, thank you, Judge Pizzuto. The call center, as Judge Pizzuto said, is a brand new endeavor that we are very excited about. It was an idea that started several years ago, but took on new life once the pandemic hit. With support of Judge Carroll, Judge Pizzuto, Ty Christer, Roberta Palmer, and many others, the call center was created in a matter of months. We wanted to come up with ways to maximize the branch's limited resources by removing some tasks that could be handled through a central location. And phone calls really are one of the easiest activities that could be centralized. And by doing so, it allows the clerk's office staff to focus more on their core court functions. So on August 3rd, the Superior Court Call Center started answering calls. We started by answering calls just for the courts in the Hartford Judicial District that handle the civil, criminal, family, and housing matters. And we are gradually adding JDs every few weeks until all of the courts will be online with the call center by in the early months of next year. So reaching the call center is transparent to the caller. All the callers dial the same numbers that they've always dialed to reach the clerk's offices. For the courts that are being answered by the call center, those calls are going to be answered by the call center staff. And if you're dialing a phone number that hasn't been rolled into the call center yet, you'll be answered by, or the call will be answered by the court. So currently we have 8 judicial districts, which equates to about 24 courts that are having their calls answered by the call center. The remaining 6 judicial districts, or 16 courts, are expected to be answered again early next year. The volume, on average, we handle about 1,200 calls a day in the call center. On Mondays, our busiest days, we are answering about 1,600 calls. So far, since we've opened, we've taken 72,000 calls, and that's all being handled in a central location here in Hartford. So most of the calls are handled by call center staff. There is a small percentage of calls that do need to be sent back to the clerk's offices. And most of those relate to the criminal motor vehicle case matters because there is not an electronic version of the file. So the file resides in the clerk's offices, so that's where we need to send the calls at times. The work of the call center goes beyond just answering the phones. Staff there also provides full service experience by providing information and assistance in other areas such as form completion, how to request copies or decrees or orders. We also walk them through accessing information on the judicial website, such as our divorce navigator. We refer callers to available non-judicial resources as well, such as where to find programs to satisfy court-mandated programs in the age of COVID, such as our parenting courses that are out there. Staff also sends several emails a day with instructions and forms. For example, we may get calls about how to request a motion for contempt. So rather than just answer the call, we do provide them with instructions on how to fill out the forms. And we actually email the blank forms and provide them instructions on where to send them back. So it's more than just answering calls. We provide a full service experience to the extent that we can. And for those that do not have access to technology, because that is out there, as we've been discussing today, we print the forms and we send them to them by U.S. Post Office mail. We are able to answer calls by phone, which again is a benefit during this age of COVID because it reduces the foot traffic in the courts. Some other benefits is that we allow people to leave voicemails in the callback feature, which is a very neat feature because it allows people to leave their phone number so that when the agent is available, they'll get a call immediately back when the agent is available, and they will not lose their place in line. We also have improved delivery of services and efficiency because callers can call a single location and have a lot of their needs met from multiple court locations. So gone are the days of having to call Hartford and then hang up and then call Stanford. You can call a single location and be able to get your needs from multiple locations handled by that single call. We also have the ability to add in a language interpreting service for any callers that need so. We're able to add the interpreter. We have the call center staff on the line. We have the caller on the line, and we're able to speak with that caller in their native language and be able to assist them. And if we need to transfer the call to the court, we're able to send all parties to the court so that that caller does not need to start over again and explain what they are seeking. And then finally, one of the more significant and longer term goals is to identify ways to increase uniformity across the state and provide a similar experience for each caller, regardless of what court they're calling for. So if you're calling for Hartford or you're calling for New London, our longer term goal is to make sure that everyone is receiving a similar experience. So, thank you.
Thank you, Stacy. Thank you, Judge Bizzuto. Judge Bizzuto, is there anything else that you want to cover in your report that you did not have a chance to? I didn't want to.
No, I hit all the high points.
Okay. So I want to, oh, go ahead.
No, Krista will let me know if I've missed anything. I'd ask her to at least chime in.
Krista?
No, you didn't. You didn't miss anything. It was perfect. Thank you.
Jay has a question.
Okay, great. That's exactly what I was going to do, to ask if anyone has any comments or questions for Judge Bizzuto, for Stacy, and or Krista. Attorney Saxton.
So two things. The first is just for the remote rooms that you guys now have in the Superior Court. Are those rooms that could be used for self-reps who have an appellate argument? Because I was just thinking about, and I seem to recall, Judge Bright or Justice Kahn, you can speak to this more if I'm wrong, but particularly in the beginning of the pandemic, when we started doing the remote video arguments, we were not really including a lot of the self-rep parties last spring. And now that we've gone back to remote arguments again in the appellate court and Supreme Court for December, and I imagine will be the January or February terms as well, that, having a place where someone who doesn't have a reliable internet connection or doesn't have that type of equipment could go to participate in a family appeal, would be really helpful.
Yeah, I mean, I don't, from a technological standpoint, it certainly is doable, right? They just, on the Teams platform, you could be anywhere in the world and participate. So I don't, I know it was definitely planned for the trial courts, but I don't see it being a problem if there's an appeal with a pro se who wants to participate as well. And, there's a location open, convenient to wherever they may live, that they could, use that room. I don't see that being a problem. I mean, I'm glad you brought it up, because that really wasn't kind of in the thought process when we were trying to get these up and running in the various JD locations. But I don't know, Krista, you were more intimately involved in, the planning behind, and I think there's going to be 35 of them across the state. So there's going to be plenty.
There are, and as it's envisioned right now, they are. So they're likely not to be used for just walk-ins. I mean, in an ideal world, they'll be scheduled by case flow, so we'll know who doesn't have the technology. But I think they're available as long as the technology works. And the technology we're looking at right now is this great. It's amazing because it literally was not available when we started this discussion. It's called the Yay Link or something. It's a phone with a small screen. It's touchless. Because we had some very strong concerns about bringing self-represented parties into court, or anyone into court for that matter, and having them go into a room that someone else had just been in testifying and touching the same. And so this is a touchless system. The clerk calls into it. It's automated. It picks up automatically. It disconnects automatically. So it's really, props. I'm not sure if Lucio's on the call, but our IT department, as Judge Bizzuto knows, is just amazing. They're off the hook. So yeah, I mean, to the extent it's available, I think it should be utilized when and where possible. Sure.
I also, if I could, thank you, Judge Bizzuto and Krista. Attorney Saxton, I don't want to speak for Judge Bright in the appellate court because I don't know, but I can tell you that as far as the Supreme Court, if anyone has any issues with access to technology, but they can only appear remotely, I suppose they can discuss them with obviously Paul Harton or Carolyn Ziogas of the clerk's office. But I can tell you that this past term, we had a self-represented litigant, appellant. He happened to be incarcerated, but we were able to do the entire oral argument with him appearing remotely. We are set up for that. So I don't see why it couldn't be done with Superior Court, assuming, you know, of course, Judge Bizzuto and Krista and Ty Erickson were involved in organizing it. I don't see why it couldn't happen.
So if I could just chime in, I think this is great. We went back to remote hearings this past week. It all went fine. We had a couple self-reps who were able to accept the team invitation and use their personal devices to participate in the argument. But we've talked about what happens if the person says, I don't have an internet connection or I don't have a smart device. And our solution has been to tell them that they can argue telephonically, and that's how they're going to have to do it. But that obviously is not as good as having them appear by video. So, Krista, would it be possible for you to provide the information on this system to Carolyn Ziogas so she can provide it to the case managers? And then if a case manager gets a call from a litigant who says, how am I supposed to do this remote argument because I don't have access to internet or otherwise, they can discuss scheduling the argument through one of these 35 sites.
I certainly will. I can tell you that they don't exist yet.
Okay.
The rooms have been, the space has been identified, the equipment has been identified, and I had a meeting with IT before this meeting. We're probably looking at 3 to 5 weeks in terms of ordering. Obviously equipment takes a while to come in now, so it's not up and running yet, but all things being imminent, they will be soon.
Well, that's good. I mean, we're just about done with our third term. We have some cases beginning of next week, but then we're not going to start hearing cases again until January. So
okay, that may work.
So that timing works perfectly for me, which is awesome.
And as far as the Supreme Court, we have our we're starting our fourth term on Monday, but it's a shorter term. It's only 10 cases, and then it'll be 5 weeks before we start the fifth term. So we too can, wait for the technology, but in the meantime may make arrangements. And Judge Bright, maybe Judge Bright and I are on the reopening committee. Maybe we can communicate with Carolyn and Paul Harton as well. If you think that would be a good idea, Judge Bright.
Yeah, I was after we got off of this, I was going to get a hold of Jill Begeman, who's our Paul Harton at the appellate court, and tell her about this and ask her to kind of follow up with Paul and with the clerk's office and let them know that Krista or someone else may be reaching out to them and tell them about this.
Great. I was actually thinking exactly the same thing in reaching out to Paul. So that's terrific. I want to keep the meeting going. We have 7 minutes left. I want to be sure that Judge Bizzuto and Krista and Stacy have presented their piece, because I think it's critical for all of those in attendance to understand what we're rolling out, what the branch is doing in terms of access to justice under COVID. Anything further at Judge Bizzuto?
No, thank you.
Okay. There are a couple of things that I do want to cover and then turn it over to Stacy to talk about the scheduling of the next meeting. I hope you're finding that these meetings are useful in terms of even just sharing information about the various access to justice challenges and initiatives that we have. So does anyone have any critical pressing question that they want to ask Judge Bizzuto before we move on? Okay, seeing none, I'm going to give you combine 5 and 6, items 5 and 6, so that I leave enough time for Stacy to wrap up in terms of our meeting going forward. So as to item 5, I just wanted to report that I attended the ABA National Meeting of the State of the Access to Justice Commission co-chairs. I know Judge Bizzuto participated as well, as did Stacy and Alex Gillette and others. I know that you all received an email from Stacy and Alex with links to register. The program was free. The nice thing about COVID is that all of a sudden we could attend this national meeting and attend it for free. I had an entire report prepared, but I'm just going to give you the highlights. I was honored to participate in the opening plenary session and to co-conduct or co-host or moderate the meeting of the co-chairs with Judge Yuhas of California. The focus of our ATJ National Conference this year was, where is the Access to Justice movement going, headed in 2020 and beyond? And the focus was addressing access to justice in light of disasters. Obviously, COVID being the one we're currently dealing with, but we also covered issues around natural or man-made disasters, including malware, hacking. And then the second issue was racial justice in light of recent events, and how does racial justice intersect with access to justice? As you know, our mission covers the mission of our Access to Justice Commission includes providing access to justice to the most vulnerable communities, including ensuring racial justice in access to justice. So that was a big focus of the meeting. There were several plenary sessions, including one on the urgency of now the role of ATJC commissions in confronting racism to advance civil justice, and there was also one on civil legal aid funding in a time of COVID-19. There were various table talks, and I'm not going to be able to list them all. Stacy will be sending out a link to the national, to the website that contains the tape recordings of all of these programs and table talks. I had meant to ask any of you who attended. Certainly a lot of our lawyers handling legal aid, working for legal aid agencies, attend the meeting and the conference. And I was hoping to hear from them, but we'll table that for the next meeting. But we'll send out a link. You can look at all the table talks. And the closing plenary addressed how we expand access to justice through the local ATJ committees. As far as new efforts or other efforts, I wanted to highlight two things, and you'll be getting a link right after this meeting. You'll be getting a link to this as well. One is the Connecticut Bar Association and the Connecticut Bar Foundation created a program to address racial justice called Constance Baker Motley Speaker Series on Racial Inequality. We'll send you the link. There have been several programs. There's one coming up on, I believe the one coming up is on prisons and incarceration. There have been programs on racial justice in financial dealings, education, not necessarily all focused on court systems, zoning issues, voter access to voting. So I encourage you to go through that link, and the programs are quite interesting. The next new effort that I wanted to bring to your attention is, as a result of this year's national conference, Shubi Diorius, who's the director of the Access to Justice National Commission, created a new racial justice work group. I'm actually co-chairing that with Judge Yuhas, and several groups have already, several states have already joined our work group, and they include Tennessee, Washington State, Virginia, California, Arkansas, New York, Indiana, Montana, and Oklahoma, and we expect more. There will be a series of programs, probably quarterly, and of course, I will ask Stacy to send out emails to you with links to those programs as they become available. Right now, it's it's a work in progress. We're going to have a meeting in early January to kind of plan the programming, and we're meeting or discussing aspects of it via email. But we do have meetings set up, and I'll report more on that. I'm excited to be part of that national work group. So we have only like 2 minutes left. I'm going to turn it over to Stacy to talk to you about our next meeting.
All right, so this will be very quick. We're hoping to have a meeting before the end of this year, so that's why we went with Friday, because of availability. And because it was Friday, we picked the earlier time versus having it at the standard 2 o'clock. But for our next meeting, we are looking at going back to either a Tuesday or Thursday at 2 o'clock. There are 2 meeting dates that we're looking at that I'd like to get your sense as to which one may work for you. The first one is March 11th, 2021 or April 13th, 2021. How does March 11th work for everyone? Okay, how does April 13th work for everyone? Okay, does anyone have a preference? If not, Justice Khan, do you want to go with the March 11th date?
Yes, why don't we go with March 11th, unless anyone has right now knows they have an issue with that. Seeing no one raising their hand objecting to that date, let's plan, if you can mark your calendars, March 11th, and when we send out the email with the links, we'll send the reminder of March 11th so that you can save the date, and we'll send you reminders, of course, in advance. I would ask every work group to meet prior to that March 11th. And I think the focus of the reporting for the work groups next at our next meeting will include what are the lessons we've learned from COVID? What can we take from this experience that can assist us in thinking outside the box and improving access to justice in general? So we'll be asking that of all of you. I want to thank you for your patience, for your time. I know it's a lot to ask 2 hours. We meet quarterly, but as you can see, it's really important for us to communicate and find out what our respective agencies, employers, entities, organizations are doing, because I think in sharing this information, we can help each other and we can provide the greatest access. So I want to thank all our work groups, all the individuals who reported today, some of whom got very last minute notice. And most of all, I want to thank Stacy Franklin, who without her putting this together, it wouldn't happen. And so I thank her, a million thanks. And of course, Judge Bizzuto for her support, and Ty and Krista, who are also influential in putting this together. Anything before we end our meeting at 1:02?
Mm-hmm. Thank you, everyone. Have a good weekend.
Thank you. Stay safe, everyone.
Thanks
so
everybody.
much.
Stay
safe. Happy holidays.
Stay safe and happy holidays to everyone.
To you too.
Thank you, you too.
Thanks, Sharon.